Good afternoon. Good afternoon, participants. Thank you so much for being with us for so long and for being with us since yesterday. I'm going to talk about the Resolve a Dispute Challenge. Before I talk about it, let me definitely commend Honorable Justice Jumoke O. Pedro, Chairman of Council, for leading the Council so effectively. We're about to talk about the Resolve a Dispute Challenge. It is an initiative of the Lagos Multi-Door Courthouse. The Resolve a Dispute Challenge is an initiative of the Lagos Multi-Door Courthouse and first of its kind that focuses on court docket decongestion and the promotion of increased resolution of disputes through non-adversarial means, particularly mediation. Now, what are the objectives of the Resolve a Dispute Challenge? The objectives are: 1, increased access to justice; mindset change in approaches to dispute resolution; promotion of court docket decongestion, and so on and so forth. What is the essence of the Resolve a Dispute Challenge? What we're looking to do is next year, 2025, within a span of time, we're going to request particular institutions, the judiciary, and law firms to buy into this Resolve a Dispute Challenge. We expect that all these institutions, the judiciary, will be able to resolve disputes or contribute to the resolution of disputes within a space of about 9 to 10 months. And the highest number of people or institutions or judges or magistrates to resolve disputes or contribute to the resolution of these disputes will get an award. Hello, do we understand the challenge? Do we understand the challenge? I don't think we do, so I'm going to repeat it. We are launching a program. It's called the Resolve a Dispute Challenge. What it is that we are going to be looking to honorable judges, honorable magistrates, law firms, institutions, mediators to resolve a dispute within a space of time. For instance, if you resolve 300 disputes within the space of time and you're the highest number, you get the highest number, you get the first position under that category. Do we get it now? So if you are an institution and you are able to refer as many as 300 cases or 200 cases and you are the highest referral institution, you get an award. If you are a judge and you refer the highest number, you get an award. If you are a magistrate, you refer the highest number, you get an award. And we're pushing this narrative from next year, 2025. Please give the Governing Council a round of applause.
To the glory of God, we want to unveil what we have here. In the name of God the Father, God the Son, and God the Holy Spirit.
Let me quickly say that this is an initiative of the Lagos Multi-Door Courthouse under the able leadership of Mrs. Sachere Cole, the director of Lagos Multi-Door Courthouse. So they are the ones promoting this in order to ensure that the dockets of the courts, that they are free from congestion. Thank you very much for doing that. God bless you.
The honor to invite to the stage the chairman of this session, Honorable Justice R.I.B. Adebi. Please, a clap for her. The speaker, Mr. Kehinde Aino, SAN, OFR. Managing partner, Aino Blankson. Please, can we welcome him with a clap? The moderator, Ms. Osareme Ezekiel, Managing Partner, Oakwell Partners, Member, LMDC Panel of Neutrals. You are welcome, Ms. Ezekiel, to the stage. Mr. Aino-san, you're welcome. We welcome the panelists, Honorable Justice L.A.M. Folami, Judge, Lagos State Judiciary, and member, Lagos Multidor Courthouse Council. My lady, you're welcome. Professor Ayodele Asenoa, Deputy Vice Chancellor, University of Lagos, Professor of Law and former Dean, Faculty of Law. You're welcome, Prof. Mazi Afam Osigwe, SAN, President, Nigerian Bar Association. Unfortunately, he has been waiting to join this panel, but due to time differences, I think he has something else to attend to. He might not be able to join us online any longer. Then Mr. Olatunde Busari, SAN, FCIS, FCIAB, Managing Partner, Akinwumi and Busari, LP. Thank you very much, son. At this point, may I hand over to the chairman of this panel session, Honorable Justice R.I.B. Adebi.
My lords, distinguished ladies and gentlemen, I think I can stand or sit on all existing protocol. Well, welcome to session 3. You can see that we could barely take our seats before we were being asked to start. So time is of the essence, and we'll do our best to keep to the time. I believe we have an hour. And we have very distinguished speakers. We don't have an hour? How long do we have? 45 minutes. 40 minutes. Okay. 40 minutes, realistically. Thank you. So once again, welcome to session 3, Legal Framework and Regulatory Support for ADR in Commercial Disputes. You will agree with me that without the legal framework, without the regulatory supports, we can't get very far in ADR. We have had legal framework so far. We've had regulatory support. It is clear we need more to be able to achieve the purpose for which we want, how far we want ADR to go. The legal backing is important. We need to inspire confidence amongst the users of ADR, adaptability and reliability. Our commercial disputes are numerous. They are not localized. The disputes are more and more cross-border disputes. In fact, they're getting more and more intricate because we have transactions that are consummated in several jurisdictions. The supplier is somewhere else, the buyer is somewhere else, the transporter is somewhere else, the delivery man is somewhere else, and then something goes wrong. How do we resolve all those disputes? Our speaker today is the visionary of LMDC, Mr. Kehinde Aina. He founded Lagos Multidor Courthouse. Please give him a round of applause. What Mr. Aina did was that he didn't keep the ADR knowledge and the ADR expertise and what he saw as the vision of ADR to himself. He started ADR privately in the Negotiation and Conflict Management Group. And it was that he came and brought to the table, to the High Court of Lagos State. And that was how LMDC was founded in 2002. So let's once again give Mr. Aina a round of applause. We appreciate you, Mr. Aina. And I'll hand over to you. So we agree that there's no one better than Mr. Aina to speak to us about the legal framework and the regulatory, and regulatory support for ADR in commercial disputes. So you have 10 minutes to speak to us. Thank you. Over to you.
Can we give him a round?
Thank you.
You can be seated.
It will be very, very difficult for me to remain seated when my lords are in the room. I'm not very used to it. Let me commence by recognizing my lord, the chair of the Lagos Multi-Door Courthouse Governing Committee, Honorable Justice Jumoke Pedro. I want to also recognize the chair of this particular session, Justice Adebi, and thank you indeed for your kind words. My lords who are here present, I also welcome you and I thank you indeed. Panel members, it's also a pleasure to share the stage with you at this time. Let me say this. When you have an organization which has survived 20 years, I believe that it calls for celebration. It's an unusual feat in our country. Now, when that organization and the idea that births the organization itself and the building which houses it gets gutted by fire, and the idea in itself did not die, then it calls for double celebration. I do believe that the credit for that feat, it's only important to recognize that the credit for that feat and that success story is not resident within the beauty of the idea and the promise it represents alone, but much more than anything else, on the leadership of the judiciary by Honorable Justice Kazeem Olanrewaju Alogba. I want to thank him. I want to thank the chair of the Governing Council Committee, and I want to thank indeed all the members of staff for what they have done, because they have really produced something that is quite outstanding to a large extent. In addressing the topic to speak to today, I would like to premise that topic, which is about the legal framework and regulatory support for ADR in commercial disputes.
I'm sorry to interrupt you. Can we please have silence, please, so that we can properly enjoy the presentation? I know it's difficult with the RSVP going on, but please, let's have some quiet. Thank you.
I want to
Hello, quiet, please. Thank you.
So let me premise it before I address my thoughts and my propositions in terms of legal framework with two fundamental realities which I think we all should be able to relate with, or then at least connect ourselves with. Because if we do not connect ourselves with that, it might be difficult for us to design or contemplate any legal framework whatsoever that we can even rely upon to a large extent. The first reality which I want us to think about is what I call economic growth and judicial response. Economic growth and judicial response, the troubling mismatch. Now, in the 20 years of the existence of the Lagos Multi-Door Courthouse, the state of the economy, the global economy today, is completely different. That's even an understatement. If we begin to understand the reality of what that represents, then we'll begin to come to terms with where we are and also where we are not as far as judicial response and as far as the Lagos Multi-Door Courthouse. Couple of indications. Between June 2023 and July 2024, Sub-Saharan Africa was trading in cryptocurrency in the region of $66 billion. Sub-Saharan Africa. And taking the lead in that regard, in that trading, was Nigeria. Now, in terms of mobile money transactions, which is what the likes of Alibaba, Amazon, PayPal, and so many of them deal with transactions in today, Sub-Saharan in itself, in terms of mobile, was in the region of $495 billion in the year 2020 alone. Think about it. In the year 2020 alone, $495 billion. Now, in terms of the same mobile money, the United States in 7 years, in the year 2016, was trading in mobile money at the sum of about $1.6 trillion. About 7 years after, by 2023, the United States was in mobile money at about $6 trillion. But you know what's interesting? As far as mobile money is concerned, all over the globe, in Southern Africa, Nigeria is taking the lead. Nigeria is taking the lead. Now, it is not something to cheer about. Why? The judicial response does not match the reality. The state of our judiciary and even the legal response and the laws does not match the reality. Judiciary is not just outmanned, it's not just outgunned, it is out-economied, if there can be a word like that. What does that mean? Beginning to become some dinosaur of sorts whose days are truly numbered. I make the point and I say this. If the judiciary were to be a business, it will be out of business. I make no mistake. As far as dispute resolution and dealing with transactions are concerned, there's competition. And the competition is not visible for us to see. The nature of the transactions today and the volume of those transactions are not the sort that we can deal with the apparatus of justice as presently constituted. It is not going to work. That's my first reality for us to think about. What is the second reality? The second reality relates to the subject of commercial disputes and the nature of those commercial disputes today. And I refer to that in terms of what I call the BHS syndrome. Why the transactions today are borderless, they are hydra-headed, and they are sophisticated. The nature of the dispute we're talking about today. Historically, the kind of disputes that we all grew to understand was along the lines of landlord and tenant, breach of contract, supply chain and supply and demand, debt recovery, and all of that. Today's dispute is nothing like that. Absolutely nothing like that. Let's wake up to this reality. Let's wake up. We just need to understand where things are going. Otherwise, we just one day, nobody will walk into our courtrooms anymore. We'll wake up one day and the lawyers will see that their phones are not ringing anymore. We'll wake up one day and see that their courthouses and the courtrooms would need to be translated to something else. If we learned nothing from COVID, is to realize that structures and buildings matter no more. Courtrooms is not the answer to the challenge no more. We need to outthink this process. One of the problems I think we have is that we tend to throw people at our challenges without thinking about the strategy and what is required before we throw people at them. You must design the way to solve the problem before you throw people at them. Solution must precede people, personnel, not the other way around. Not the other way around. The appointment of judges Let's appoint 100 more judges. You won't solve the problem. Not today's reality. Most of the transactions don't even come to court. They don't need the courts. eBay, Google, Amazon, they already have their resolution mechanisms embedded within their operations. And I'm glad my law teacher is here. We must teach even the lawyers differently to wake up to the reality. So question is, what is the answer? And what exactly are the things for us to contemplate? The answer for me came in part, and this might seem a little bit, weird. The answer for me came in part with I don't know whether you listened to it or you all heard it, with the Nobel Prize announcement in October. Now, in October, Nobel for the first time, and listen to this, the Nobel Committee for the first time in the history of Nobel Prize given, in 2020, for the first time, Nobel Committee gave the prize for physics and chemistry, not for human intelligence. They were given for artificial intelligence. Now, a gentleman from Princeton University by the name of John Upfield, another gentleman who is the godfather of AI, known as Geoffrey Hinton, who is the professor at the University of Toronto, jointly won the prize for physics on account of their research and their knowledge and what they've been able to do with machine learning, which is powering artificial intelligence. They began this in the 1980s. So today they've been recognized. Now, on the flip side, the CEO of DeepMind, which is a subsidiary of Google AI, also won the prize in chemistry. Now, if we understand the import of this, because what has happened is that very development would transform the world completely. And if we don't wake up to realize that if we choose not to align with those reality, then we're missing the boat. Because the train is already moving. And we're late already. Countries all over the world are aligning their realities to see what to do and how best to move things forward in that regard. So what then do we do? My fundamental thought is that the court registry is what I call the promising, prodigal, abandoned child of the judiciary. It is the prodigal, abandoned child of the judiciary. I think there is a fundamental mistake that I think we make as lawyers and as judicial officers by repeatedly following what I call the standard judicial handbook, which is that for every challenge in terms of justice service delivery, there are three things we do. We focus on the rules of court and see what amendments it needs. We focus on the buildings and building more courtrooms. Our judiciary will go to Obalende, go to LB, go to everywhere, just looking for courtrooms. Before you know it, we're going to be looking for courtrooms in my house. And we're going to be asking lawyers for spaces for courtrooms. It is ridiculous. It's not just ridiculous, I think it's appalling, if you ask me. We address courtrooms, and then we appoint much more judges. Truth be told, that's not where it is. Then what happens to the registry? Nothing. It is within the registry of the courts that I believe the answer lies. And it's in that registry that you can begin to look at what the Nobel has done and the promise of artificial intelligence, particularly generative AI. What generative AI does and what the ethics is all about, if there is one industry that is absolutely suited for artificial intelligence, particularly generative AI, is a system like that is based on precedents. There is nothing judges can provide or judgment that they can deliver better than AI. Because you feed all that you have done in the past into it, and the answer is clear. Once the answer is clear, litigants come in and then begin to negotiate, and don't waste your time. We don't need an admit judge to determine what case should go to where. Generative AI will determine that. The chief judge does not have to waste his time trying to filter through cases. It's a waste of resources, a waste of time, it's a waste of intelligence. It is outdated, it is archaic, and it is primitive. Where then do we go? What are my recommendations finally before I yield? I have 3 suggestions in my final comments in the paper I gave. And the first thing I said was that I made reference to Mia Motley, somebody that I know quite a bit because of what she's doing on the climate change, an area of great interest and passion to me. And Mia Motley at a conference in Paris made a very interesting point, and then she said, what we need in terms of change is no longer about reforms. We need transformation. Let's forget reforming the justice system. Let's transform it. Let's break it down and rebuild it. Let's rethink the way and manner we operate, and then let's start afresh and ensure we can align what we do with the realities of the 21st century and the demands of the corporations today in order to ensure that we can remain relevant. In doing that, there are 4 things I've suggested. Number 1, the registry. We must rethink, retool, and reorganize and redesign the registry. Therein lies the answer. When the American embassy, if you remember, was having problems in terms of bookings for appointments to go to the American embassy, and people were lining up, it was not solved by building another embassy to ensure be able to get attended in good time. It was done by technology. If they can do that, so what's wrong with it? Must our level of conservatism and rigidity stop us from being able to apply these realities to how we operate? That's the first thing. The second thing for me also is about the multi-door courthouse in itself and the way and manner we see the multi-door courthouse. Connected to the registry in itself, today the multi-door courthouse remains, truth be told, or a side chick to the judiciary. Honestly, we've got to change that mindset and have the multi-door courthouse fully embedded within the operations of the judiciary. The real multi-door courthouse is part and parcel of the system. They must be brought in and be integrated. That's when you can have the fullest operations of the multi-door courthouse. Because when the generative AI within the registry is able to take a poll and determine what case is best for what, based on agreed criteria, it will say, this case should go to, what is wrong with having a mediation judge? What's wrong with it? What's wrong with having a judge for litigation? What's wrong with it? I think we should be a little bit more flexible with our thoughts and then see exactly what we need to do and then see what we can make a difference in that regard. Undoubtedly, all this I'm saying requires a good level of regulation. There are challenges associated to it, but the challenges can be overcome. The promise of generative AI will make a lot of difference to everything we stand for, everything we represent, and be able to make a sea change in that regard. And it is in that regard that a number of regulatory framework and also legal requirements can then be dealt with. It's been a pleasure indeed. Thank you for your time.
Thank you very much indeed, Mr. Kendi, I know, SAN. Can we give him another round of applause? Thank you very much for that very insightful and timely presentation. So 3 takeaways before I hand over to the other speakers, and particularly our moderator, but I would like to introduce the other speakers. From that presentation, 3 takeaways for me. Judiciary as a business, if we analyze it, would be out of business. I then pose the question, what about the legal profession itself? If the profession doesn't change, it's going to affect all of us. The other thing is about the nature of disputes that have changed. I think I had mentioned that earlier in my introductory remarks. And then the most profound one was solutions must receive people, not people ahead of solutions. And Mr. Aino has suggested or postulated that there needs to be severe transformation in the legal process or the legal profession for us to be able to properly embrace ADR. So thank you once again for those profound remarks. We have, and we're very privileged to have with us, Professor Asenwa, who has been able to, the Deputy Vice Chancellor of University of Lagos, who's been able to join us today. We're very happy to have you here with us, who will be speaking to us briefly on the role of national legislation in supporting ADR mechanisms. Mr. Tunde Busari, SAN, who is an accomplished arbitrator, who will be speaking about cross-border commercial disputes and international arbitration. And our own Honorable Justice Folami, who will be giving us some remarks. She's a judge of the High Court of Lagos State, a member of the Governing Council, and in the General Civil Division. Thank you very much. At this stage, I'll hand over to our moderator, Ms. Ezekiel, and I trust that you'll maintain the time frame that we have. Thank you.
Thank you very much, Milord. Good afternoon, distinguished ladies and gentlemen. All protocols duly observed. We're welcome to this panel discussion where we'll be talking about how laws and policies promote ADR. This is a topic that a lot of us are familiar with and I can relate to. As a mediator, I realize the importance of having ADR backed by law. I mean, it enables us have a structure. It enables ADR have a structure. It enables it have an appeal, both locally and internationally, such that the economy grows and foreign investors know that there is a deliberate, defined, speedy, and enforceable way of resolving disputes if and when they occur. Because the issue is not will they occur, they will occur, is when they occur. So this encourages international trade or global trade as you would have it. As the chair has said, a panel of distinguished personalities have their unique perspectives on the importance of law and policies in the promotion of ADR. And they'll be sharing their thoughts with us along 3 different topics. Thank you, Mr. Aino, for that very innovative paper. What I heard from that paper, or one of the things I heard, is transformation. And not just transformation, absolute transformation. You've said that absolute transformation is key. And you've spoken about generative AI as a tool to bring about that much needed transformation. We'll try to situate some of the things you've said in our topics to be taken by the panelists. Our first panelist, ladies and gentlemen, is Professor Asenwa. And we all know that national legislation plays a huge role in supporting ADR mechanisms. We are all aware of the latest legislation that we have, one key one that we have, which is the Arbitration and Mediation Act 2023, the AMA, which regulates arbitration and mediation processes. Professor Asenwa, what would you say is the role of national legislation in the support of ADR? I'd like to hear your thoughts on this.
Thank you very much, Madam Chair of Session, as well as Madam Moderator. What is the role of law in supporting ADR? I think it's all been said. Nothing is legal except it is legal. And although admittedly, if the law does not prohibit it, then it probably is not illegal until the law wakes up and clearly says this is illegal. So when you have a practice evolving in the way that ADR evolved, in the way that mediation evolved, and mediation more particularly, with little framework coming out of law, you can get away with it for some time. But after some time, you need a framework to support what is done. Because we have seen cases, even in relation to arbitration, come out. And we have seen such cases throw up doubts that touch on the integrity of the process. So we find again that we need to begin to, in quote, document and assert what are the standards, that is, the standards that are acceptable in every form of ADR. When does it, and those standards are the things that lend to its integrity, that causes people to repose trust in it. I think it was either the moderator or Mr. Ino who said earlier on that if people are going to trust the system, if someone says, let's have an arbitration clause in this agreement, the first question your client should ask you is, what does that mean for me? What does that mean for me in terms of which arbitration law, for example? I always have to deal with that in UNILAG because when we have MOUs with our partners, usually when they come up with the MOU, they want the laws relating to arbitration, mediation in their jurisdiction. And we want the laws in our jurisdiction because we need to anticipate the effect of that. So usually you'll find that we need to have laws in a way that everybody can search and know what it is, and then they can anticipate and assess the risks that is entailed. We also need laws because if you do not have laws that make it part of the process, so especially when it becomes an alternative, a legitimate alternative to the usual litigation, you need a law that validates that. I remember in the early years of the OPD and CMC, and I was part of that because I was on the board of OPD. There were those who will not honor. When OPD started, it wasn't a creation of law. It was just a division of the Ministry of Justice. There were those who would not honor any letter because their lawyers would have told them, it's not coming from anywhere. If your employee has a dispute, let him go to court. If whatever, let him go to court. But there was a change when both the OPD and the CMC became backed by law. OPD is the Office of the Public Defender, and it has power to mediate. CMC is a Citizens Mediation Center. It became a completely different ball game when there was law to back up what that institution was doing. So law also helps to, especially when it's being put forward as the alternative that it is, we need to legitimize. You can have people consent, but yes, beyond, consent assumes that two people will consent. And we also know that law has helped us to be able to have pre-action ADR, diversions that say, before you go to action, litigation, you must do this. We enjoyed a lot of that in the area of criminal justice, especially with restorative justice for some types of smaller offenses. So it's really, and I think it's also important. I know that most of the people who are here are interested in commercial disputes and the look at, but also I know the multi-door courthouse takes so many of all those others. So it's about understanding that law grants legitimacy, law helps you to standardize, and reassuring for all of the system.
Thank you very much, Professor Senua.
So sorry to interrupt you, Madam Moderator. I understand we have online the NBA President, Mr. Afa Mosigwe, SAN. We welcome you, and just for you to note so that you can direct your questions to him. Thank you. Thank you, MBA President. You are welcome.
Thank you, Prof. We hear you loud and clear what you've said, that we need laws to give a backing or a bite to ADR. We need to document standards to give it legitimacy and transparency, which is basically what is needed. How effective would you say the AMA 2023 has been in promoting ADR since its enactment?
Thank you very much. Certainly much better than where we're coming from, to the extent that we even have recognition given to mediation at all. Mediation at all. And because in the past it was arbitration and conciliation, and then conciliation tended to be more of trade disputes and all of those things. So I think it's far-reaching. I think it's very, very far-reaching. And I think that, but what's important, and which we often don't do, is that we do not actually structure periodic evaluation. What we should do is not just to hazard guesses about what its faults are, but to undertake an empirical study. We could say 2 years on, let's say, or we could say 3 years on, let's see, from real life cases, from impact. And then we're going to, I can talk about individual experiences. I can talk about articles that I've read where people have engaged some clauses. But I probably, because I come from academia, would want to understand more from an empirical perspective, where I'm able to say it is not just one case. It is, this is what you get. So I am looking forward to a study, and I'm hopeful that some of my colleagues who are now experts in the university in ADR will actually be looking at evaluation studies 2 years on, and we are analyzing from cases, not just the textual review that was more commonplace in academics, where you just look at the text and you criticize. It should have said should, but it is saying may.
Thank you very much, Professor Senua. Evaluation is key, evaluation of our laws to see the practicality in terms of area from this perspective. Would you say that there is a disconnect still between, okay, time, all right, thank you very much, Professor Asenwa. We have only enough time for two questions at this stage. We need to move on so we can, okay, we'll quickly go on to talk about the role of cross-border commercial disputes and talk about cross-border commercial institutes and international disputes rather than international arbitration. Welcome, Mr. Tunde Busari, SAN. In our increasingly international and interconnected global economy, businesses are engaging in transactions that span multiple jurisdictions, sometimes leading to real disputes with hydra-headed positions. We'll now explore the dynamics of cross-border commercial disputes and the critical role that they play. Can you quickly please share your thoughts on what legislative regime you would say governs international arbitration?
Thank you very much. I stand on the existing protocol, Madam Chair, and my lords. Arbitration, no country or no jurisdiction is an island unto itself. So you find that international or transnational trade continues to grow. And at the same pace, you have cross-border disputes. Now, if you go anywhere, the question they ask you is that if you want us to bring our investment to your country, what is your judicial system like? What is your arbitration and ADR regime like? And all they are asking for is that can we safeguard our investments in your jurisdiction. Now, the United Nations International Trade Law has done commendable well. As we speak, there are various working groups, and you find out that they keep coming up with model laws. Those model laws are there, even against your wish. If you don't want to grow at the pace of the international committee, they are serving you with already made laws that you can domesticate. Happily, one of such is the New York Convention. The New York Convention 1958 has been domesticated by about 172 countries of the world. What that means is that if there is an international arbitration and an award, they have confidence that it can be enforced in your country for as long as you are a signatory. So there are conditions that must be fulfilled, and that is, it includes that the two parties are, they have capacity, that the award or the subject matter is not against public policy, that the arbitrator has not dealt with matters not referred to him or her. I will not bore you with theoretical issues, but the good thing is that Nigeria is one of the countries that has domesticated the New York Convention. The New York Convention. You can see it in our Schedule 2 of the Arbitration and Mediation Act. Secondly is the model law that I spoke about. There is the model law that most countries have adopted as the Arbitration and Mediation Act, and Nigeria is not an exception. The ACA 1988 was modeled after the UN model law, the arbitration model law, the ancestral model law, and also the 2023 Arbitration and Mediation Act, also fashioned after the the model law, after the ancestral model law. Yeah. Then there are so many things to consider in international arbitration. Potentially, unlike the domestic arbitration, where you have just the law of Nigeria that applies, if you have an international arbitration, potentially there can be five laws that you consider. Laws of the parties, laws of the seat, laws of the place of enforcement, and so on and so forth. So you have to pay attention to all that. And I must make a distinction. The ICSID arbitration, which is the International Center for Investment of International Center for Settlement of Investment Disputes. Award of the ICSID does not lend itself to recognition or enforcement by a national court. It's not the discretion of the national court. You must recognize it and enforce it once it is an ICSID arbitration. And that is where the difference comes in. There are implications to all this. And I'll just also give you a practical example. As a special assistant to the Honorable Attorney General Minister of Justice, I led a delegation to the United Nations Working Group on Online Dispute Resolution. And I raised a question that at that time, our Evidence Act had not acknowledged electronic evidence. We had not incorporated it. So I raised that issue that all these principles that you are formulating for the international community, how will it apply to countries where they have not really recognized electronic evidence? In a cheeky fashion, after answering my question, one of them now said that if the whole world is moving on and Nigeria refuses to move at the same pace, the world will not wait for Nigeria. So I came back and gave that message to my principal. And I'm sure that may not have been unconnected with why we must change our Evidence Act, review it such that online dispute resolution will also be relevant. However, till date, even though Nigeria participated in the fashioning of the online dispute resolution model law, I'm not sure that we have domesticated it such that if an issue arises and it relates to international dispute on online, Nigeria might not find itself up to date. Then secondly, with international arbitration, we need to be sure that we up our game, because Nigeria may not favorably compare with Singapore, favorably compare with places like London as seat of arbitration of France, because anybody that wants to choose a seat for the arbitration, we want to be sure that you are compliant and that the advantages that London offers, the advantages that they see in France, are also present in Nigeria. So, notably, those legislations are what you cannot ignore. The ICSID Convention, the New York Convention, and then the UNCITRAL model law, where international arbitration is concerned.
Thank you very much, Mr. Busari. So how easy then would you say it is to enforce cross-border claims, given these deficiencies you've talked about in the situation of our laws?
Well, with cross-border recognition, there is a difference between recognition and enforcement. In some countries, you will have to apply for recognition of your award before applying for enforcement. Fortunately, our legislation in Nigeria not only recognizes foreign awards, but at the same time, you can apply for recognition and enforcement by virtue of the fact that, like I said, the New York Convention has been domesticated into our Schedule 2 of the Arbitration and Mediation Act. And my experience in our courts, in truth, and not because I'm here with my lords in attendance, my experience with our courts is that once you can persuade them that you have fulfilled the provisions of Article 5 of the New York Convention, which is also will be Article 5 of our Schedule 2, they do not hesitate to not only recognize, but also to enforce. In some countries, it could be easier. In Ghana, for instance, there are law, which I think they've reviewed as well lately. Once you have an international award, all you need to do, they said, by written application to the judge. So when they say written application, I'm not sure whether you will formally bring an application to the court or that their environment is so user-friendly such that by writing, the judge will minute on it and send it to the bailiff or to the sheriff to levy execution. But what makes an environment attractive for enforcement of international arbitration is the willingness of the judiciary to adopt or recognize or allow and support the enforcement of foreign arbitral award. And in Nigeria as well, to tailor it along other arbitration-friendly jurisdictions, an award can only be set aside under very limited ambit. It's so limited. Under the old law, because our colleagues would define misconduct in several ways, because there are so many cases that are expanded, now, under, I think it's Section 55 of the AMA, they have actually defined the grounds upon which you can bring an application to seek to set aside. And I must say again, because I'm talking about international arbitration or international award, an award may have been set aside in a different jurisdiction and it remains valid and enforceable in another jurisdiction. An example is the UCOS arbitration, which I'm sure is still live today. UCOS arbitration was an arbitration against the Russian government. It was set aside in the Netherlands, being the seat of the arbitration. However, they sought recognition in Belgium, America, and France. And because time will not permit me to tell you the distinction between the civil country and the common law countries, they are more flexible and they allow arbitration to thrive more in civil law environments. France entertained and treated that award as not having been set aside. If you look at the provisions of Article 5, as I mentioned, it says an award will be recognized, the recognition and enforcement of an award will be refused under the following conditions. May be refused, rather, maybe. And in France, they said, look, this is an international award. it does not subject itself to domestic law. Therefore, it may have been set aside by the law of Netherlands, which is the domestic law. It remains a life award in France. And they looked into it, and they recognized it. However, they did not enforce it on a different condition, because it was an enforcement against the property of the Russian government. And they said you could levy execution against the property of the government only if it is being used for commercial purpose. If it is being used for diplomatic purpose, you cannot levy execution against it. Time will not permit me to talk more about the workings and the nuances of international commercial arbitration. But if you want me to address other issues, I'll be willing to.
Thank you very much. Thank you very much, Mr. Busari, SAN. Mr. Busari, SAN is one of the leading arbitrators in Nigeria today. Thank you for that very educating and succinct expatiation of international arbitration using the cross-border commercial disputes. I'm told that our time is up, but we have Milord Justice Folami, who is also a panelist. Milord, can you just quickly contribute to the discourse the session?
Good afternoon, Chairman of the Governing Council. Good afternoon, Chairman of the session, and all protocols duly observed. I thank you for this opportunity, Madam Moderator. My own contribution, I'll go right back to the speaker, to his paper. I had the privilege of going through the paper, before today, and I found it very interesting, the angle with which he took the topic, saying that the future definitely is not, the way we see it today. The future of disputes will not be the way we see it today. He stated that the solution we often have to dispute solving number of cases we have is often building more courtrooms, appointing more judges, making more rules. That's what we've been doing. But like he told us, the future is going to be different. But as a judge of the High Court of Lagos State, and luckily for those of us that are already on the bench, we have more than enough work to do, at least for the foreseeable future. We just see more and more cases coming before us. Now, he had a very interesting angle. He talked about an area that is completely forgotten, which is the court registries, which is said that he thinks that that is where the reform should start from. And I agree with him, really. But having said that, I also want to agree with Professor Ashenwa that legal framework is important, because if we look at the LMDC today, we'll find out that in the past, when Mr. Aino started his work, LMDC was court connected, and they were doing their own thing. High Court was there on its own. But once we reformed our civil procedural rules and made the LMDC part and parcel of our rules, it was a different ballgame. Now all cases are referred compulsorily to the LMDC, even before they come before the pre-trial judge. So what I want to say is that on the bench today, there's some cases that we see, and they come up repeatedly, and it has to do with arbitration. You find out that people go to, before they come together, they have an agreement and say that if there's any dispute over this agreement, there's an arbitral clause that we're going to go to arbitration. But rather than them doing that, they still like to come to court. They will still come to court and say they want this dispute resolved. And then it will still take us, if we're not careful, it will still take us about a year to get to that. We first of all go through, have you served the other party? Is the other party in court? All of that. Before we now say, write a ruling and say, but you had an arbitral clause in this agreement. You're supposed to go to arbitration. Please, this case is adjourned sine die, or, you strike it out. So that's where what Mr. Aino is talking about comes into play. If we make use of AI as a tool to sieve out some of these cases, such that, but we will need the legal framework, such that on the first day they come to court, the judge can tell them right away that, look, you have an arbitral clause in your agreement. You have no business being in court. We can do away with some of these cases. So that's my own intervention. That is where AI will really help us with the registry. They would be able to use AI to sieve out some of these cases that don't need to be in court in the first place, but then they will need the legal framework. Thank you.
Thank you, my Lord, for reiterating the importance of legal framework being essential, to the growth of ADR. I would, in the absence of time, I would, as we wrap up, quickly just ask our panelists to make one quick or one last statement, on the issue. And I would like to start with Professor Asenwa. One last statement. What would you like the participants to go away with today in the absence of our being able to ask them questions?
Thank you. I think that I'm going to just throw out something we can do together. So the students in my university are very big on tech now, and we have about 4 digital tech hubs. And the students concentrate the solutions around fintech. Or maybe. And I have always raised the issue. Why is no one responding to some of the legal challenges that we have? And I would just want to invite maybe LMDC and whoever here. Let's actually begin to throw out the problems. So fine, you want to use AI to identify that in this particular agreement, you have a clause on ADR. It assumes that you have, you've written, you have some applications through which you're going to process the submissions, and it will just throw up, and it will throw up a lot more. All of those things require some coding, some writing, Mr. Aino talked about, taking your disputes to that's the future, really. We're going to be taking our disputes, to some, we're just going to be lodging them, and the decisions will be made. But the bottom line is that we have to enter the data. But I don't foresee a time that humans will not play a significant role, because the jurisprudence that the robots will do, or the AI, the machine learning intelligence is going to use is one that you and I probably evolved as we reflected. And so I think the future is going to be pretty interesting, but we need to leave this place, not just with thinking about the prospects, but giving ourselves some timeline. And of course, I challenge myself also, because, we also need to look, and this is where we need support. I'm glad the MBA chair is on the call. We need to look at the curriculum, and we need to make things like ADR integral, not add-on, not co-curricular.
On a lighter note, I cannot resist sharing this with you. Yesterday, I asked the AI on my phone a question. I said, when you sit down, do you button your jacket? The first statement, he said, as I'm not a real human being, I do not wear jackets. But indeed, the world is moving, and we must catch up with what is going on in the world. I will leave you on the note, because we are the practitioners, we are the stakeholders, we are the users of ADR and all the methods of dispute resolution. There are so many concepts that are now second nature in developed countries. And some of them have been integrated into our Arbitration and Mediation Act. Some of them are being introduced. But if you look at third-party funding, I haven't seen an example of third-party funding, even though it's been incorporated into the AMA. As users, as practitioners, such concepts we should make sure that it becomes what will practice, what will apply to our dispute resolution mechanism, because it takes the pressure off the litigants and it makes the access to justice. You cannot, on account of not having money, now be deprived of what is your rights or what are your remedies. Rise of life science arbitration, immunity of arbitrators, mass arbitration, and as the speaker has said, Mr. Kende, climate change and investment treaty arbitration, crypto asset disputes, those are huge opportunities. People are talking about crypto, but the way they talk about crypto here, and we see it as a 419 thing, as a Yahoo thing, it has a different commercial, international connotation elsewhere. We should convert it to advantage in our own system, in our own climate. Post-mergers and acquisition disputes, geographical impact on energy and infrastructural disputes, increased use of virtual arbitration. Yes, we have mastered that. Growing importance of emergency arbitration. I recall that I was in London not too long, about 4 years ago. Kigali International Arbitration Center had just been established. And then they were looking for somebody close by who could come and man their emergency arbitration proceedings. When they called me, I was in London, and I said, yes, I can do it. I answered as if I do it every day. But that was the first time I was going to do it. I said, yes, I'm available. I said, but I'm in London. Can you ship me to Rwanda and ship me back to London? They said, yes, because the emergency arbitration proceedings must start and end within 15 days. If you are going to have a hearing, the hearing must be incorporated within the 15 days, and you write your award. Of course, I saw it as an opportunity, and I jumped at it, and I did it within 15 days. Now, thank you. Now it is commonplace. We have it in our own Arbitration and Mediation Act. Expanding role of artificial intelligence. Mr. Kennedy, I know stressed on it because that is the future. We cannot be left behind. And again, as practitioners, I think we should not shy away from enlightening ourselves, from educating ourselves, right from how you formulate your arbitration clause. People do ask, how do we not make a mistake? There are so many institutional clauses. The ICC is there, the IC is there, the LCI is there, Negotiation and Conflict Management Group model clause is there, the Chartered Arbitration model clause is there. Let's pick it up and adapt it, and we will not make mistakes. For international arbitration, it's taking a lot of, it's prime because the parties do not trust the judicial system or the venue of the other party. A Frenchman will not want to go to Ghana. A Ghanaian will not trust the system in France. What is the solution? Let us look at institutional arbitration. Let us see how we can make Lagos Multi-Door Courthouse look like a genuinely neutral forum. If we can, let us extend our list of neutrals to include foreigners, to include experts, such that when they say, I'm referring to my dispute to Lagos Multi-Door Courthouse, they have an opportunity of choosing a Russian who is also in the panel of neutral. Thank you very much.
Thank you very much, Mr. Busari, SAN, for that very ingenious contribution. Ladies and gentlemen, it is clear that by integrating or incorporating AI within our legal frameworks, we can enhance case management, access to justice, support efficient resolution of commercial disputes. I dare say that we have a number of takeaways and nuggets from the discourse today. And I want to thank a panel of discussants and our speaker and our chair for the very succinct contributions to the discourse of the day. Thank you very much.
Thank you very much indeed. Can we give a round of applause to our panelists and our excellent moderator? I think we have a closing remark from our speaker. So before we close officially, I'll hand over to Mr. Ino to make his comments. Thank you.
Thank you, my Lord. Thank you indeed. Three quick final points for me. One is that if Lagos State were to be a country, it will undoubtedly be one of the fastest growing economies in the world. Now, with that said, just like my very good and bosom friend Tunde Busari has indicated, if we structure the Lagos multi-door courthouse appropriately and stand positioned to place it within the international community, that is certainly one gateway to showcase not just the judiciary, but also showcase Nigeria and Africa. And the point he made in terms of expanding the purview of the panel of neutrals to include arbitrators and international people of note is something not to be ignored. And I think it is really possible to do this because dispute resolution administrators and the whole essence of it is not important where you are located. Location is of no consequence. Lagos multi-door courthouse is an idea whose time has not just come, but is way ahead of its time. It can have operations and relevance in the space, as it were. Its address today should be in the clouds. It's not in Lagos. It's only by Lagos by virtue of name and name alone. So I think we should have that sort of mindset in order to see how that can happen. That's number one. Final point for me also is that one of the things that we are very good at a lot of talk shows, conferences, workshops, and truly speaking, nothing happens afterwards. So for the most part, when I get invitations, and I've got quite a few this year in Nigeria, I pick the ones I attend. And most of the time I don't go because nothing happens. What I would like to frankly recommend is to follow the example of the Pound Conference in 1973, which birthed the multi-door courthouse concept. After Frank Sander made his presentation, what they did was to create a small committee. And that committee was to look at the ideas that had been presented on that day and then begin to see what to do with it. So there's been 4 panels, 2 panels already. This is the third. There'll be a 4th. The question and the challenge for me and for us all is to see how we can pull those ideas into some meaningful resource and do something with it. And let's agree on some definitive steps forward and see what ideas make sense and how do we time it, how do we fund it, and also how does the realities happen at the end of the day, because it doesn't get any better than this. Thank you so very much indeed.
Thank you very much indeed, Mr. Ino. I would like to appreciate in absentia the MBA chair who wasn't able to join us. I don't know what happened. Maybe it was a technology issue. But we're counting on the MBA. This is work that we have to do together. And it's a shame he wasn't able to join us, but we count on his support. The issue of the advocacy of ADR, the legal profession, being in the forefront of ADR and seeing the future of ADR and seeing the fact that we cannot do it without ADR is very, very key indeed. So we appreciate you, MBA President, and look forward to your working with us on moving things forward. On that note, I'd like to once again appreciate all our panelists, distinguished speaker, excellent moderator, my colleague, Honorable Justice Folami, my lords and my distinguished ladies and gentlemen, for your rapt attention. We appreciate you greatly, and thank you very much. Thank you. So we can take our photograph now.
Yeah, we can quickly take the photographs. The photo session, please.